ask yourself a question: why some people are really good at what they do and reach consistently great results in comparison to the rest of specialists in their area? Well, I've been absolutely fascinated by this question and spent a lot of time researching it. And what I realized is this: true specialists with special skills and deep knowledge work out the structures, the systems of their trades, and then apply these structures and systems on a consistent basis. This allows them to bring consistently amazing results over and over again. Hello, my dearest friends. My name is Svetlana Shlapak, and I'm a senior immigration solicitor based in London, UK. And I'm also the creator of this free ukvisasuccess.com channel. I won my first immigration case at the tribunal back in 2003, and this gives me over 15 years of experience in UK immigration field. I've created another special video series for you called Deconstructing Immigration Rules, where I've deconstructed over 30 immigration categories for you. I've created this video series with only one aim: to help you understand the structure of immigration rules, because knowing the structure always helps achieve astonishing results. And for those of you who want to see how to apply this structure in practice, you can also check my other video series where I show you how to do exactly that. It is called ukvisasuccess.com frequently asked questions. Okay, let us deconstruct your next immigration category. And yes, my friends, immigration law is a very, very deep area of law. I can only take so much of your time during each video, and as much as I love to, I have to be very succinct and choose the most important parts to explain to you during these videos. If after watching these videos you decide that you would like to know more, please visit ukvisasuccess.com more, as at this page I've provided you with the links to great free in-depth material which will help you on your way to success with your immigration matter. In today's video, I would like to explain to you the suitability requirements for any entry clearance application made under Appendix FM. Appendix FM is a part of immigration rule which defines the rules for the decision makers to consider the applications made by family members of someone who is either settled in the UK or who is a British citizen. And when you submit your application, irrespective whether you submit it as a partner, as a child, or as a dependent relative, etc., then you need to persuade the decision maker that you meet all the suitability requirements. This is the starting point. This is where they begin considering your application. And there are two types of suitability requirements: mandatory suitability requirements and discretionary suitability requirements. Mandatory suitability requirements is when the decision maker has no choice but to refuse your application if you're caught by one or more mandatory grounds for refusal. And discretionary grounds for refusal, as the name suggests, means that the decision maker has a discretion as to whether or not grant your application if you are caught by one of the discretionary reasons for refusal. There are 8 mandatory grounds for refusal. The first one is when the exclusion from the UK is conducive to public good. The second one is when the applicant is subject to a deportation order. Third one is all about convictions. So if a person was convicted for more than 4 years, this means that their application will always be refused and their conviction will never be spent. And therefore, if someone has got criminal convictions and they were convicted for more than 4 years, they will never be allowed to enter the UK. If they were convicted between 12 months to 4 years, they will only be allowed to enter the UK if more than 10 years have passed since the conviction, and if they were convicted for less than 12 months, then they will need to wait for 5 years before they can make their entry clearance application to enter the UK. Fourth mandatory reason for refusal is when exclusion is desirable due to conduct, character, or associations of the person who applies. Number 5 is when a person failed to attend an interview, provide some information, or provide some physical data, or undergo a medical examination, or provide a medical report. Mandatory reason for refusal number 6 is when a person is not allowed to enter the UK for medical reasons. Number 7 is when they previously left or were removed from the UK because of the caution which was given under Section 22 of the Criminal Justice Act 2003. So basically, this is also connected with criminal convictions. And number 8, this is also a mandatory ground for refusal, is when there was an offense against a child, or where a person is a registered sex offender and they failed to comply with the requirements, or where they were required to comply with the sexual risk order and they failed to do so. Discretionary grounds for refusal. There are 5 discretionary grounds. The first one is when the applicant, whether or not, this is really important, whether or not with the applicant's knowledge or without, because there were cases where false information was provided by the applicant's relatives without their knowledge. It doesn't really matter. Or there were even cases where this false information was provided by the applicant's representative. It doesn't really matter. What they say is then when either false information, representations, or documents were provided, or there was a failure to disclose material facts, the application may be refused on discretionary grounds. Second discretionary reason for refusal is when there was a failure to provide a maintenance and accommodation undertaking, when they were requested to do so and they failed to provide this undertaking. Third one is when the exclusion is conducive to public good because of the non-custodial sentence or some other court disposal which was made within less than 12 months of making the application, or their offense has caused some serious harm to the person, or the person who is applying is a persistent offender. Fourth discretionary grounds for refusal is when there was a failure to pay litigation costs awarded to the Home Office. And fifth reason for refusal, discretionary ground for refusal, is when there was a failure to repay a debt to NHS and this debt was more than £500. And one final thing, if you're a spouse or a partner of a British citizen and you are living abroad and are thinking of joining your spouse in the UK, then you will greatly benefit by checking out my free mind map. This mind map will help you with one crucial thing. It will help you avoid one of the most common mistakes people make when submitting their visa applications to enter the UK as spouses or British citizens or someone who's settled in the UK. This mind map is completely free and you'll find the link in the description. And one final thing, if you're a spouse or a partner of a British citizen and you are living abroad and are thinking of joining your spouse in the UK, then you will greatly benefit by checking out my free mind map. This mind map will help you with one crucial thing. It will help you avoid one of the most common mistakes people make when submitting their visa applications to enter the UK as spouses or British citizens or someone who's settled in the UK. This mind map is completely free and you'll find the link in the description. And one final thing, if you're a spouse or a partner of a British citizen and you are living abroad and are thinking of joining your spouse in the UK, then you will greatly benefit by checking out my free mind map. This mind map will help you with one crucial thing. It will help you avoid one of the most common mistakes people make when submitting their visa applications to enter the UK as spouses or British citizens or someone who's settled in the UK. This mind map is completely free and you'll find the link in the description.